Good afternoon. I'd like to say a really warm welcome to everyone and thank you for taking the time to connect with us today. By way of introductions, I'm Sarah Coles. I'm a partner heading up the medical negligence team in our Leeds office, and I'm delighted to be your host for today. I'm also joined by Joanne Fraser, partner in the Court of Protection team, and she today will be helping us all understand a bit more about the role of the Court of Protection in relation to property and affairs, particularly in respect of children. Before I hand over to Joanne, I'd like to thank all of you who've already submitted some questions. You can submit further questions throughout the session via the Q&A function on your screen, and we will answer them at the end. If I could ask, when you're submitting the questions, if you could please include your name and email address, so that if we don't get a chance to answer that question, we can respond directly to you afterwards. This is going to be a recording and the link will be sent to you following the end of the session. And towards the end of the session as well, we will be posting a feedback link. So again, if I could just ask you at the end to take a couple of minutes, just let's have your feedback about it all. So with all the housekeeping having been done, I would now like to hand over to Joanne Fraser, who'll take it from here. Thanks, Jo.
Thanks, Sarah. Hi, everyone. Thank you for joining me today. I hope that you find the session useful and informative. Sarah's obviously kindly just given an introduction about who I am, but I specialise in court of protection matters relating to property and affairs, and I have specialised in this area for about 15 years now. I work with children and adults, majority of whom have sustained a traumatic brain injury, and I assist them in the management of their property and affairs. And part of this work is about supporting and assisting my clients' families in understanding the court of protection process and also decision making. So in today's presentation, I intend to cover a bit of an introduction to the Court of Protection, an overview of the Mental Capacity Act 2005. I'll touch upon the test for capacity. Then I'll go into the role of a property and affairs deputy, and then I'll finish with a brief overview of lasting powers of attorneys. And as Sarah said, happy to take questions at the end. Next slide, please. So, the Court of Protection. Well, the Court of Protection is a specialist court which helps people who don't have mental capacity to manage their own affairs. The court has the power to make decisions for people about their money, property, health and welfare. Now, in respect of children, the Court of Protection only has jurisdiction to deal with matters concerning a child's property and affairs if, on the balance of probabilities, that child is unlikely to have capacity when they are an adult, and that's really important. In respect of welfare, health and welfare matters concerning children, the Court of Protection has no jurisdiction in respect of such matters, and they fall to the family courts and obviously to parents. So the court can also give powers to somebody else to make decisions on behalf of individuals who lack capacity, and they do that by usually appointing a deputy, and I'll come on to that shortly. But the court will only appoint a deputy when the court decides, based upon medical evidence, that a person lacks capacity to manage their finances, where a series of decisions is required, so it's got to be long term, and where the court considers that there is no less restrictive way of managing that person's affairs. Next slide, please. So the court has two arms to it. It can deal with health and welfare matters and also property and affairs. So I'm not going to go into detail in respect of health and welfare matters, as that's outside my specialism, but the court can, for those aged 16 and older, be asked to make decisions about someone's health and welfare or appoint a health and welfare deputy. In respect of property and affairs matters, the court can either make a one-off order if an application is made. For example, if authority is required where an individual lacks capacity and monies need to be withdrawn from that person's bank account and no other provision is in place which authorises somebody else to make such decisions, then the court can be asked to make a one-off order providing that authority. And I've put an example on there about requesting money from a child's bank account or savings account once they are 16 years of age, and I know we've had a couple of questions on that which I can deal with at the end. The Court of Protection can consider the appointment of a Property and Affairs Deputy as to whether this should be a professional appointment, i.e. a solicitor who's got expertise in the area, or whether it can be a lay person such as a family member or friend. And the court can also consider the removal of deputies if there has potentially relations, if there's been any disputes that need to be resolved, or potentially if somebody's regained capacity. And the court can also deal with matters concerning attorneys under a lasting power of attorney, which again I'm going to touch on at the end of this session. Next slide, please. So the Mental Capacity Act 2005 is the legislation that applies to Court of Protection matters, and the Act itself was implemented in 2007. The Act's main purpose is to protect and empower those individuals that cannot make decisions for themselves. Now, the Act itself applies to young adults and adults, so i.e. age 16 and over, but it doesn't apply to children. So the purpose of the Act is to enable those adults and young children to make decisions as they're able to do in their own right. It also provides provisions so that individuals can plan for the future at a time when they may not have capacity to make decisions for themselves, and can make things such as powers of attorney or advanced decisions in relating to medical treatment. The Act provides the provision for another person to be appointed to make decisions about personal welfare or property and affairs, and it allows best interest decisions for adults and young adults when no future provision has been put in place for a time when they're going to lack capacity to make such decisions for themselves. The Act goes on as well to provide clarity and safeguarding to those who lack capacity. It's a very useful tool and provides a framework and overall guidance to follow when decisions need to be made on behalf of somebody else who lacks capacity in their own right. Next slide, please. So who does the Mental Capacity Act apply to? So it applies to both children and adults. Now, in respect of children, we're talking more so young adults aged 16 and over. The Mental Capacity Act, as I said before, is a framework in respect of decision making that needs to take place, and it can apply to some people who have a learning disability. It could be as a result of mental health problems, brain injury or illnesses such as dementia and Alzheimer's, but can also include people with autism. Parents of children who have disabilities or additional needs need to be aware of the Act and its potential implications for their role in decision making, particularly when their child reaches the age of 16, as that's when things really start to change, and that's when we see a transition in who is able to make decisions. The Act itself applies to everyone who looks after or cares for somebody who lacks capacity to make particular decisions for themselves. So not only parents, but it also applies to informal carers, paid carers, and anyone else involved in the welfare of somebody who lacks capacity. And the ethos behind the Act is to empower, protect, participate, and be as flexible as possible around the decision-making process. Next slide, please. So, the Mental Capacity Act it provides the legal framework to be applied by those acting on behalf of someone who lacks capacity to make a particular decision for themselves. So I've already touched upon the fact that it applies to parents, informal carers, but it also applies to anybody appointed in capacity as a deputy or an attorney, and the judges in the Court of Protection and the Office of the Public Guardian, who's the supervising body of the court, also have to have regard to the principles of the Mental Capacity Act. Now, the Code of Practice, which is available online, is a very useful guide which details how the Act applies practically day to day. The Code of Practice provides examples as to how the principles of the Mental Capacity Act affect day-to-day decision making, and those people who need to have regard to the Mental Capacity Act should familiarise themselves with the Code of Practice. And as I said, it is accessible online in a variety of different formats. So the Mental Capacity Act has 5 guiding principles, and these are really important for anybody who needs to make decisions on behalf of another person. And the starting point is you always assume capacity. So there is a presumption of capacity. So it's only when an individual is not able to make a decision for themselves should a decision be made on their behalf. If somebody is needing to make a decision, you must give them all necessary support in order for them to try and make that decision on their own. So take all practical steps necessary. And that could be, for example, making sure that the individual has all the available information relevant to the particular decision that they need to make. So if it was to do with budgeting and how much money potentially could be spent on a weekly basis to meet that person's needs, it may be that the individual is provided with a detailed breakdown of what they're spending, their expenditure is likely to be. And if they require tools such as pictures or diagrams to support their understanding, then these should be made available. There is not one size fits all here. It's about the individual and what you can do to support them. It's also really important to understand that an unwise decision does not mean the individual lacks capacity. If you think about your own day-to-day activity, we probably all make unwise decisions daily. You know, buying something online that maybe we don't necessarily need, you know, and I know during lockdown I've probably made a number of different purchases that probably aren't essential, but just because they're unwise decisions doesn't mean that I lack the capacity to make a decision, and nobody should be deemed to lack capacity because of that. Where an individual is not able to make a decision, so once points 1 to 3 have been followed, and a decision needs to be made on behalf of that individual, then any decision made needs to be done by taking into account what is in that person's best interests. And that's really important, because in order to determine best interests, then whoever the decision maker is should be consulting with anyone who has an interest in that individual's affairs and welfare. And by discussing the various options available and what the potential outcomes could be, and obtaining opinion, thoughts and views of all other persons when reaching a best interest decision. But also best interest also includes the past, present feelings and wishes of the individual who lacks capacity. You know, what would they want to have happened? And that all has to be factored into the decision making process. And ultimately, you also have to consider that when making a decision on behalf of somebody else, that the least restrictive option is applied. Next slide, please. So how is capacity tested? So the Mental Capacity Act contains a 2-stage test of capacity, which is detailed in section 2 of the Act. And the starting point is to ask, has there been an impairment of or a disturbance in the functioning of the person's mind or brain? And secondly, does the impairment or disturbance mean that the person is unable to make decisions with regard to their property and financial affairs? Now, it's important to note that decision making is time and decision specific. So somebody can lack capacity to make a decision in respect of one matter, but have capacity in respect of others. So an example is that an individual may lack capacity to make decisions about a large sum of money, but they may have capacity to make a will. So it's really important that the decision in question that the test of capacity is applied in respect of that. Also, time is very relevant here, because an individual may be better at certain parts in the day of making decisions. So, for instance, an individual may be better off making a decision in the morning because they're able to function better before levels of fatigue, etc., kick in later on in the day, and that has to be taken into account. And if there's quite a complex decision that needs to be made, then this should be looked at over a period of time as well, because it may be that this individual requires a bit of additional support to understand the decision in question, and it has to, their capacity needs to be assessed at different times in the day. You also have to consider fluctuating capacity, because that can occur and is a relevant factor here. Ideally, capacity should be assessed by a medical professional, a GP who's got experience in that area. If there was a personal injury claim, an expert in the claim, it could be a neuropsychologist, but it can also be a social worker who again's got experience in mental capacity aspects. For children, as I touched on at the beginning, capacity related matters in respect of property and affairs, then the Court of Protection can only take jurisdiction if on the balance of probabilities that child is likely to continue to have capacity, to lack capacity when they are an adult. Now, for some children, it may be that if they're too young, an assessment, it may not be appropriate for an assessment to take place, and you might have to wait until the child's a little bit older. It really depends on the nature of the injuries or the nature of the disabilities, and a medical expert would be able to comment upon the appropriate time. Capacity should also always be kept under review, because capacity can change, and that's really important. So not only should capacity be reviewed in respect of the particular decisions that need to be made, but capacity overall should be reviewed on a regular basis, or if there's any major changes in that individual's life. Next slide, please. So, in respect of the capacity test, if someone's capacity is being assessed, then the key information here and the key areas that need to be looked at is about assessing whether the individual can understand the information about the decision to be made. So what decision is it that actually needs to be made here? Do they understand the nature of this decision? Can they retain the information relating to the decision that needs to be made? And then can they use or weigh up that information as part of the decision-making process? And finally, can that decision be communicated by whatever means necessary? I.e., do they need to use a specific device for communication means? Does it mean that a picture has to be, that they draw a picture in respect of it? Can they verbally communicate it? But it's really important that each of those individual requirements is ticked off in respect of assessing somebody's capacity to determine whether they have capacity in respect of that particular decision. Next slide, please. So best interest, touched upon that previously. So the Mental Capacity Act actually sets out a very helpful best interest criteria checklist, which should be applied when a decision needs to be made on behalf of someone that lacks capacity. So as far as possible, and this is clearly set out in the Act, the decision maker should consider the person's past and present wishes and feelings. And to determine those, it might be that you have to talk to people involved in that individual's welfare. Determine what the beliefs and values would likely to have been if this individual had capacity, and also factors they would consider if they were able to do so. And the views of others is very important, and they should be consulted if appropriate. And that could be anyone who's named by somebody to be consulted, somebody caring for that individual, or who's got an interest in their welfare. It could be somebody appointed under a power of attorney, or a deputy appointed by the court. Next slide, please. So how does the Act benefit families and carers? So it provides informal carers with a source of assistance and guidance in respect of decisions that may need to be made day to day on behalf of someone that lacks capacity. And the Code of Practice provides a really useful guide in respect of those decisions and how the Mental Capacity Act applies in a day-to-day scenario. It also offers protection to individuals who could be vulnerable, who lack capacity to make decisions, because there's a clear framework as to what needs to be applied when that individual may not be able to make a decision in their own right. It's also, you know, a useful tool for parents to understand the implications of the Mental Capacity Act, particularly as their child grows older. So as a parent, you'll be used to making decisions for your child day to day. But when your child transitions and they become a young adult, 16 years and older, they in theory should be making their own decisions. And when they're 18, your role as a parent changes. You no longer are able just to make those decisions on their behalf. You can be consulted, but you don't have the final say. And that's really important to understand how the Mental Capacity Act applies in those situations, and to familiarise yourself with the framework that's clearly laid out within the Act. And it also provides protection for those who make decisions on behalf of the individual who lacks capacity. If they follow the provisions within the Act properly, offers protection. Next slide, please. So, a deputyship. So if you have a situation where we either have a child who is deemed to lack capacity on the balance of probabilities in respect of making decisions about their property and affairs when they're going to be an adult, or you have a young adult who lacks capacity in respect of their property and affairs, and we've got medical evidence, and we apply to the court for a deputy to be appointed for property and affairs, the court need to consider if it is appropriate, first of all, for a deputy to be appointed, and secondly, who that person should be. So the court, when considering the appointment of a deputy, have to take into account whether that is the most appropriate option. And if there are a series of decisions that need to be made in respect of property and affairs, then the court will ultimately appoint a deputy as opposed to making a one-off order. When the court consider the appointment of the property and affairs deputy, they will look at the value of the individual's estate. And if there is a lot of money that needs to be managed, then it may be appropriate that a professional deputy is appointed as opposed to a family member or friend. And a professional deputy tends to be a solicitor, can be an accountant, but somebody who's got expertise in that area. And a professional will charge for their work, and the Court of Protection have special hourly rates that are applied to this type of work. And all costs associated with a professional deputyship have to be submitted to the Supreme Court's Cost Office for assessment before professional deputy can be paid. The benefits, I suppose, of having a professional deputy is they have expertise in this area. They're also independent, so if there's any complex family dynamics, then having an independent appointment is usually appropriate, as it separates the obviously the personal involvement and emotion from decisions that may need to be made. In terms of a lay deputy appointment, this can be a family member or friend. You have to be 18 years of age or older, and obviously have capacity in respective matters. On application to the court for a lay deputy, a deputy's declaration has to be completed, and within that declaration you have to declare that you have had no adverse credit, that you do not have any CCJs, and that actually you are an appropriate person to take on the role of managing somebody else's finances. And you have to sign a declaration in respect of the obligations placed upon you as in your role as a lay deputy. There is the option of having a joint or joint and several deputy appointment. So if there were two family members who wanted to take on the role, you can apply jointly, which means you make decisions together, or joint and several, which means you can make decisions together but also outside of each other. And these need to be considered very carefully, and location of the individuals applying should be taken into account, because if you're in different parts of the country like to function in respect of managing a deputyship, will that work? Or if somebody was in a different country outside of the UK, how would that work in practice? There's lots of things to work through when considering who should be appointed. Next slide, please. So the role of Property Affairs Deputy is in respect of all aspects of financial management and financial decisions. So on this slide you will see a number of examples. This is by no way an exhaustive list. There are obviously lots of different aspects of finances that play a part in this, but as an example, a deputy will have the authority to purchase a property on behalf of the individual. The deputy will be able to deal with the adaptations or extension required to a property to make it suitable in respect of the individual's long-term needs. Those decisions are financial decisions. Obviously, affordability plays a big part in that, and the deputy has to consider the impact of such decisions in respect of the individual's long-term finances. The deputy can deal with the payment of bills, setting budgets to meet ongoing need, large capital expenditure. The deputy is also able to employ carers in respect of supporting the individual. So employment matters can be dealt with by the deputy alongside the instruction of appropriate therapists. The deputy can get involved in dealing with state funding or continuing healthcare matters. The deputy is able to deal with the application of and receipt of benefits that the individual may be entitled to, and the deputy is under an obligation to ensure that that individual is claiming the appropriate benefits and keeps them under review. So if there's a change of circumstances, they take the necessary steps to ensure the benefit entitlement is looked at and considered should any changes be needed. The deputy has a deputy bank account where, as far as possible, all of the individual's income and expenditure should go through there, and the deputy can also look to invest the individual's funds in order to maximise capital growth, to ensure the funds last as long as possible, but obviously investments have to be done in the most appropriate way, and therefore the deputy is authorised to instruct a suitably qualified and experienced financial advisor in respect of those matters. The deputy also has to ensure that they submit an annual report to the Office of the Public Guardian, who is the supervisory arm of the Court of Protection, and the annual report sets out all decisions that have been made in the last 12 months by the deputy, and also a detailed account of income and expenditure, so the court's able to see how those funds have been managed. In terms of a will, then in order to make a will, you have to be 18 and have testamentary capacity, and this is something a deputy should look at in respect of their role. And it may be that if an individual lacks capacity to make a will, that a statutory will has to be applied for, which is an application to the Court of Protection in respect of what those testamentary wishes should be. Next slide, please. So how can a professional help? So in respect of the work that I do and supporting my clients, in my role as a Court of Protection specialist, then I provide supporting guidance on property and affairs deputyships, applications, how to apply, the roles and responsibilities, and I support families who wish to apply themselves or take on the role as a professional deputy for those individuals. But professionals in this area can obviously offer advice on health and welfare matters as well, if that's their specialism. They can offer one-off meetings of advice to discuss, the individual's circumstances and steps that may need to be taken in respect of their management of their affairs. In terms of lay deputy appointments, not only deal with the application, but also offer support post the appointment of the lay deputy, so you understand what your responsibilities and duties are, and assist with the completion of annual reports or tax returns, and also deal with further applications to the Court of Protection as and when required. There's also mention on there about personal injury trusts. These are specific trusts for personal injury awards where an individual has capacity to manage their affairs, but that's just a point of reference on there. The deputy as well, the professional can link in with other professionals who have specialism in other areas that may be required in respect of someone's affairs, such as family matters, i.e. if somebody was married and maybe they needed to go through a divorce, or executing powers of attorneys that can interlink with the advice offered. Next slide, please. So next step to consider. So when looking at somebody's capacity to manage their affairs, and particularly if it relates to a child, the starting point then is the child likely to lack capacity at the age of 18? If they are, and a series of decisions is going to need to be made, then a financial deputy can be appointed before that child is 18. The application can be made at any time, provided we've got the evidence to support capacity. Also need to consider whether there's funds that require management now or in the future. So this reverts back to the question as to whether there are a series of decisions that need to be made. We've also got to consider cost and proportionality of proceeding with the Court of Protection application. Is a deputy appointment the most appropriate option here, or should it just be a one-off request for an order from the court? And I'll briefly mention costs in a moment. And then also consider alternatives. Is there a more appropriate alternative action that's required, i.e. actually having somebody appointed in capacity as appointee for benefit purposes? Is that sufficient in respect of decisions that need to be made around money management? Does the application need to be submitted now to the Court of Protection, or actually does the individual have capacity or may have capacity when they're an adult to make a power of attorney? Is that something else that can be considered before determining whether an application to the court for a property affairs deputy is actually required? Next slide, please. It's also really important in respect of capacity that this is always kept under review. If an application is made to the court for the appointment of a property and affairs deputy, this is not a lifelong role. If the individual's capacity changes at any time in their lifetime, then an application can be made for the deputy to be discharged and the individual to be restored to the management of their affairs. Next slide, please. So once a deputy has been appointed, the court will issue a deputyship order which will set out clearly the powers and restrictions of that deputy. You tend to find that a professional deputy is given wide powers and a lay deputy may have restriction placed upon them. One of the common restrictions we tend to see is in respect of property purchases or property sales. And in the deputyship orders, you generally will then see a restriction not authorising the deputy to be able to purchase a property or sell a property on behalf of the individual without obtaining further authority from the court, which means a separate application has to be submitted in respect of that property purchase or sale. And likewise with gifts, the court tend to restrict what a deputy can do in gifting money to other persons, i.e. family, and separate applications in respect of those matters would need to be submitted. Once the order has been made, the court will also set security, and the security is an insurance bond which incurs an annual premium which is paid by the individual, and it protects the individual's financial assets should the deputy do something wrong. There is then the annual reporting requirement, which I've touched upon, where the report gets sent to the Office of the Public Guardian, and the Office of the Public Guardian charge a supervision fee of the deputy of £320 a year, which again is paid for by the individual. And on appointment, the deputy has to have regard to the 5 principles set out in the Mental Capacity Act and ensure the best interest guidance and checklist is fully followed. And it's really important the deputy keeps records of any big decisions that they've made and the reasons behind it. Next slide, please. So the Court of Protection application process requires various application forms that need to be completed. So a COP1, which is the general application form setting out what you're asking the court to do, i.e. appoint you as Property Affairs Deputy, or whether it's a one-off order in respect of a particular matter. The COP3 is the medical certificate that has to be completed in respect of lack of capacity, and that would be completed by the medical practitioner and submitted with the application. There is then a statement of assets, income and expenditure in the form of COP1A, which details all of the individual's finances. A witness statement in the form of a COP24 should accompany the application, which provides background information in respect of the individual, their living circumstances, do they have a care package in place, any proposed capital expenditure that the deputy may need authority in the order to deal with, if there was a property purchase that was required or a property required adaptations. This would all be included in this witness statement so the court can fully understand the circumstances of that case and provide the relevant authority. The COP4 is the deputy's declaration, which I talked about earlier, which has to be completed by the proposed deputy, which details their own financial situation, i.e. in respect of credit, bankruptcy, CCJs, and asks the proposed deputy to go through the obligations as to what will be placed upon them and sign and certify that they're happy to take on that role. All those application documents have to be submitted to the court. The court then issue the application, and when the application is issued, then notification that the application has been made has to be served upon 3 closest relatives as a minimum, who are aged 18 and over, and also notice is provided to the individual that the application relates to. Obviously for children, notice is served upon the parents. Generally, the application process is about 6 months. With the pandemic, we've seen applications take longer than that, but there is an opportunity to expedite an application, which means using urgent provisions. If there is a really significant decision that needs to be made and the order is required as a matter of urgency, so that can be pushed through the court quicker. When the application is submitted, there is a court fee of £365 that's payable, and then the deputy bond will be put in place and the order is made. If there's any amendments required to the order once it's issued, you have 21 days to apply back to court for such amendments without incurring any further charges. Next slide, please. We've touched upon regaining capacity, so sorry, next slide. So costs. So these costs are payable by the individual that the application relates to. So there is a £365 court application fee when applying to be a deputy or applying for a one-off order. Now, fee remissions are available if the individual has capital below a certain level and if income is subject to various benefits, and this can be checked online prior to applying. When the deputy is appointed, a £100 fee is charged by the Office of the Public Guardian. There is then an annual cost of £320, which is for the Office of the Public Guardian to supervise the deputy. And again, fee remissions and exemptions do apply here. And if assets are below £21,000, then there is a minimal supervision fee of £35, which is payable yearly. The deputy bond, which is the insurance policy I mentioned, is set by the court, and the level of premium is paid annually, and that will depend upon the size of the individual's finances, so the size of their estate. And if a professional, so a solicitor, is instructed to deal with the application, whether that's for a lay deputy application, whether it's a one-off order, or whether it's for a professional deputy to be appointed, then the costs incurred will be subject to the rates set down by the court, and then those fees can be assessed by the Supreme Court Cost Office. Okay, next slide, please. So just before I finish, I have just put a couple of slides about lasting powers of attorney. So this is just a very quick overview of what a lasting power of attorney is. And it's something for those of us listening today who are aged 18 or over should consider making for themselves. A bit like how you take out an insurance policy for your house and you wouldn't drive a car without having insurance in place. A lasting power of attorney is something that should be on that checklist in respect of something that you should consider for yourself. So the lasting power of attorneys were introduced with the Mental Capacity Act, so they came into force from the 1st of October 2007. They replaced what used to be an EPA, which is an enduring power of attorney. So we still see enduring power of attorneys around today. They're still valid, but you can't make any new ones after the 1st of October 2007. So to make a lasting power of attorney, key points here are you have to have capacity to make the lasting power of attorney. You have to be aged 18 or older. And to have capacity, you've really got to understand the nature of the document. So what is a lasting power of attorney setting out to do? You have to really understand the implications of signing such a document. And it's important to consider making one sooner rather than later, as if you haven't made a lasting power of attorney, you lack capacity then in respect of decisions, a court of protection application may need to be required, and then you're going to incur the costs of such an application. So a lasting power of attorney allows a person who's aged 18 and over who has capacity to appoint someone they know and trust to make decisions on their behalf when they're no longer able to. And the person or people they appoint are called attorneys. And there's two types you can make, one in respect of property and affairs and one in respect of health and welfare. And the person who's making the lasting power of attorney is called the donor. And when making the LPA, they can decide who to appoint as their attorneys, how they are appointed. So if you appoint more than one person, do you want them appointed jointly or jointly and separately? And what restrictions or guidance you might want to put in place for the attorneys to follow. Next slide, please. So when the lasting power of attorney is made, the donor, so the person making it, has to have their signature witnessed, and they also have to consider having a certificate provider, which is an independent person who can certify that the individual has capacity, and also they must notify or choose persons to be notified that they're making a lasting power of attorney when it comes to registering it. So in order for the LPA to be fully valid and to be used, it has to be registered with the Office of the Public Guardian. You don't have to register it straight away, but then you can't use it. So it's important really to have it registered as soon as possible after it's been made. The application to register it can be made by the donor, i.e. the person making it, or the attorneys. And once the application to have it registered is submitted, there is a fee payable of £120. Again, there are fee remissions available. And after the application has been submitted, the Office of the Public Guardian will set a hearing date after 35 days. There's currently a 14-week delay on this. And if no objections have been raised within this 35-day period, the OPG will register the LPA and send it back within usually a 5-day turnaround. So in terms of objections, you have to notify persons that you're making the LPA, so they'll receive a form to tell them. And then if somebody wasn't quite happy with the fact you'd made this LPA, or they felt that you didn't have capacity, or maybe you'd been unduly influenced into making one, they can raise objections to the Office of the Public Guardian prior to the LPA being registered. But it is a very good tool to have in respect of planning for a time when you may lack capacity to make specific decisions in respect of property and affairs or health and welfare. And just to point out that the fee of £120 is payable in respect of each LPA you make. So it's £120 for a property and affairs one and £120 for health and welfare as well. And the lasting power of attorney form can be found online to complete, but I was always advised obtaining legal advice if there's any issues or potential issues around capacity. So that brings me to the end of the presentation, and apologies that I've run over, but I'm going to hand over to Sarah for our Q&A.
Thank you, Jo. Certainly a lot of things to consider there. I know we all worry about our children in the future. Obviously, even more things to consider where the child's not going to or unlikely to have capacity and be vulnerable. So let's have a look at some of the questions. Thank you everyone for submitting those. Turning first of all to the first one. They don't have a health and welfare application, but they do have a health and welfare application, but they didn't apply for the financial deputyship. The question is, do they need one for signing a tenancy agreement? Joanne, what's the position there?
So it depends on the circumstances of the case. And it depends what type of tenancy agreement you're being asked to sign, because I know in some supported living settings they'll have different terms and conditions in relation to the tenancy. This is probably one where you need a bit more information in relation to the specific circumstances, but ordinarily a tenancy agreement is a contract, and if the individual lacks capacity to understand that's the specifics of the legal contract, then you may need to have authority from the court to be able to enter into it on behalf of the individual. So that could be a one-off application, or if there are other financial decisions that may need to be made, then it may be beneficial to apply for a property and affairs deputyship at that time.
Great, thanks Joanne. And I just thought we are running slightly over, so if you do have to leave, as I say, the recording will continue, so you can pick up these answers to the questions, or if you've left your email address, we will be emailing you anyway. Staying with the property theme then, question about understanding the advantages and disadvantages of buying a property in their child's name, where the child has Down syndrome and receives higher rates of DLA. Is that something you can answer, Joanne?
I can give a very brief response, but probably again require more specialist advice. But obviously a child is not able to buy a property in their own right because they're under 18. So if a property was being purchased on their behalf, you would need the legal authority to do so in respect of obtaining this from the Court of Protection potentially. But my question here would be, where is the source of funds coming from to purchase that property? Because actually, if it's not the child's funds and it's maybe the parents, then that gives rise to a whole other discussion around gifts and trusts, which obviously is much more specialised.
Certainly a complex area and lots to think about in relation to it. In terms of being an appointee, so a couple of questions around that. Where they're already an appointee for the benefits for their child, do they then need to consider applying for a Court of Protection deputyship, and would a welfare deputyship cover that as well, or what's needed in relation to going forward for medical appointments, and do they take the parents into account? Quite a number of questions there. We'll break it down then. So if you're an appointee with benefits, do you need to have a deputyship?
Not necessarily. So if there are no other financial decisions that need to be made and there's no other money that needs to be managed, because potentially it could just be benefit income, then being an appointee serves its purpose for that role. However, if there are other financial decisions that are going to be required, then you are going to need another form of authority, i.e. either a one-off order from the court or a deputyship. So property and affairs deputyship could be a potential option, but again it depends on the individual circumstances. And then just going on to the next part of that question about health and welfare, again a health and welfare deputyship again relates to whether there's going to be a serious decisions required in respect of the individual's health and welfare. So it may be that you would need to apply for it, but in terms of medical settings and support requirements, obviously when you've got a young adult, so 16 and over, then the decision making changes because the parent no longer has, as I said before, like the final say. So it then comes down to best interests, and yes, parents are consulted, as are anybody else involved in that individual's welfare when decisions need to be made. But if you know that there are going to be a series of medical decisions or care questions that are going to arise over the course of your young adult's life, then you need to give serious thought to obtaining a health and welfare deputyship and obtain specialist advice in respect of it.
And is there sort of a financial limit in relation to it? There's another question around the same point, that there's they're managing through the appointed, being an appointee, the social care budget, but the overall budget is going to be in excess of 50,000. Looking at supported living as well, is a deputyship needed, going to be needed in relation to that?
Again, it depends, because I'm assuming that the social care budget is potentially direct payments, and each local authority will have their own set of requirements around that, and will offer managed accounts through third-party providers. So you might not necessarily need a deputyship in respect to the direct payment element, but from that, if there are other financial decisions that need to be made on behalf of the individual, I think the lady said it was her daughter in that case, then consideration does need to be given as to whether a deputyship is appropriate. But as I said on previous slides, there are costs associated with the deputyship, so you have to weigh up whether it's going to be beneficial and whether it's needed. And actually, if an appointeeship and then having a managed account through the direct payments is sufficient, you might not need to have a deputyship at that particular time. But circumstances change, and without knowing the full facts of it, it's hard to give a definite answer in respect of that.
And I suppose a very important question, what's the earliest age you should really start beginning to think about the application for deputyship?
Well, I wouldn't say that there's not a cut-off either way. It depends upon the individual. So there are children who may have significant disabilities, who it is very clear from a very young age where they will not have capacity to make decisions around their money. And for instance, in those types of cases, particularly if there was a personal injury claim, and no doubt your personal injury solicitor would advise you of this, then a deputyship may be really appropriate to have at a very early age, because there might be large amounts of money that will need to be managed at some point in the future. For children who potentially parents are just managing benefit income, then a deputyship may not be required until maybe they're post 16 onwards, and when other decisions might need to be made for them. So it's very specific to the individual circumstances, but there is no minimal age and there is no maximum age either.
Okay. And also looking at LPAs, a couple of questions about accessibility. Are there some accessible, easy read documents explaining what the LPA is for someone who has a learning disability but has capacity, and also if they can physically have capacity but can't actually physically sign the paperwork?
Yeah, so the latter point about signing is fine. Whatever your signature is, whether it's a dot, whether you do a full-on signature, then the way that the LPA is drafted would make note of however it's been signed. There's different witnessing provisions, so that won't prevent somebody from making an LPA. In terms of information available, there are obviously the Direct.gov website, which has a lot of detail around the Court of Protection and lasting powers of attorney, and there are some user-friendly downloads on there. And there are also charities who offer quite a lot of support in respect of making LPAs and Court of Protection applications, and again we'll be able to offer some quite user-friendly information, but we can take that one away, I think, and probably come back on it.
Thank you. Just a couple of more questions, and I think the next one's, would you need to become a financial deputy to access funds in a children's trust if that young person lacks capacity?
Yes, so in respect of the Child Trust Fund, then in theory on that child's 18th birthday, the money within that trust fund reverts to them and would in theory be paid out to them. Now, if they do not have capacity to manage their finances, then they can't take receipt of that money, and a parent can't take receipt of it without some sort of legal authority, which would require a Court of Protection one-off order or having a property and affairs deputy in place. So that will be required. And the same as well with bank accounts. So you may well have set up a bank account for your child. We do as parents, we might start saving for them from an early age. But and then what would normally happen is that when they're 16, that account reverts to the child and the parent signatory comes off the account. But if the child lacks capacity, they're not going to be able to access that money. And so you have to think very carefully about that. And at that point, again, either a one-off order or a property and affairs deputyship would be required in order to access those funds.
Okay, and final question, and obviously again, anyone, if you have got other questions, do contact us and we'll give you some details shortly. But the question, should you have a mental capacity assessment if you're unsure as to whether to go for deputyship or an LPA?
Yes, definitely, and any medical practitioner would be able to assess in relation to the two options. So the first is obviously, do you have capacity to manage your property and affairs? And then secondly, would you have capacity to be able to enter into a lasting power of attorney, whether it's health and welfare or property and affairs, because they're two different matters. So you can ask the assessor to specifically comment.
Thank you. I think that's as much time as we have at the moment. There are a few more questions coming in, so we'll come back to the individuals on that afterwards. But thank you, Joanne. That really was informative. And again, as I say, it gives us a lot to think about. I'd like to thank you all for joining us. If you do have any other questions, do get in touch. We've also got some further events coming up. You'll see from the screen at the moment. Next Monday, we have an event regarding welfare benefits. And then the following Monday, the 22nd, it's a discussion about relationships and sexual consent and appropriate behaviour in relation to those with, who are vulnerable. We've also got other webinars that have taken place and are forthcoming. If you go to our owenmitchell.com website, many of them have all been recorded and are archived there. Lots of really useful information around all that. And we've also got a Facebook page where it's a parent carer forum. Details are on the screen now. It's a safe space for parents to ask questions, get help and ask any further questions as well. I'd also just like to remind you to take some time just to do the feedback form if you can. And otherwise, thank you very much for sparing your time today. Hope you found it really useful. Joanne, thank you very much for sparing your time and explaining all about it. And thank you all. Have a good afternoon. Bye.